Okay, hi folks. I'm going to be doing a vlog on the topic of cohabitation property disputes, and essentially asking the question, if I'm on the title deeds of a property and might have made no contributions for the purchase of it whatsoever, am I entitled to 50% of that property? Could be a large amount of money. Before I come on to that topic, I just wanted to make some general comments about the YouTube channel and so on. I just wanted to say first and foremost, these cafe vlogs are meant to be informal, general discussion. You get to kind of meet me at a more sort of personal level, and because I'm super busy, I don't go into sort of detailed preparation for these vlogs. There may be a little bit of background music, I'm afraid. You'll have to bite the bullet or turn the volume up. Perhaps you might like the music that's sort of gently murmuring in the background in a coffee shop. I'm actually in Warsaw in Poland, where we have a back office to the London law firm. I also wanted to say that these vlogs are general information only. I mean, you really, particularly in the area of cohabitation property disputes, you will need tailored advice on your case, frankly. Now, I have also, or am also, doing simultaneously a series of sort of smaller bite-sized chunks on general civil litigation and taking the proceedings from the very earliest stages to the final stages in a civil claim. Those are more, focused, more highly prepared vlogs. They are going to be complementing Flying Solo, my book, parts 1 to 8, which I'm currently in the process of publishing. But as I say, these are cafe vlogs. I'll be looking at actual real life cases and, just letting you sort of, particularly where you're looking about, you're looking at large scale proceedings, you'll be able to just sort of, in your own good time, listen to the vlogs. And I want people to actually pick up the feeling of what it's really like, not just drop bite-sized chunks of knowledge at you. Now, I should also say that I have disabled the comments on my YouTube channel temporarily, perhaps for the short, perhaps for the midterm. I'm just getting a bit annoyed, frankly, with people who seem to have nothing better to do with their lives than like, I don't know, frogs hopping from one YouTube channel to another, or perhaps wild dogs is a better description, and just sort of cocking their legs and urinating on any channel that they, remotely don't like the look of. I mean, I get, generally very good vlogs, very good comments on the YouTube channel, but occasionally I get stupid little comments. Like I had one recently that said, "utterly pointless." I mean, how utterly pointless is that sort of comment? If you want to say something that's critical about what I'm saying as a lawyer, then that's fine. I mean, but be constructive about it and say, look, I listened to your vlog and, there's this legal issue I take exception to. Great, I've had those sorts of comments. It never harms to be polite and say, look, I've enjoyed your vlog, but X, Y, Z. Anyway, but for those who have, for the vast majority of you who have got generally constructive criticisms and comments to make about the YouTube channel, just email me from here on in. Now look, if you send us an email, if we're not too busy, we will look at it and give you some, free little bit of advice. 5-10 minutes to respond to an email doesn't break the bank. On the other hand, if you need some proper advice on your case, then use our sort of discounted Lawyer Light service. And for low value claims, we only charge 150 plus VAT an hour. And we're actually finding that sort of legal surgery is quite useful. You can send through documents, get an hour on the phone with a lawyer, and during the call they'll give you general advice, but they can also skim read any key parts of the documentation as well. Okay, so without further ado, let me address the topic. Now, I'm going to give you the headline answer to this first and then go into the detail afterwards. The answer is no, if you're faced with a robust legal team, you are very unlikely to get 50% of the property by just being on the title deeds. Yeah, typically this happens where someone is on a high salary and perhaps the other party isn't, so it's a joint mortgage, and you know, they go on the deeds, and now they have some liabilities. If you are on the mortgage, yeah, you know, in danger of being chased by the mortgage company. So yes, the answer is no, you won't get 50% if you haven't made any contributions. These aren't just contributions to the mortgage, they're contributions to the purchase of that property over time. Yes, they don't have to be purely mortgage repayments. It could be household bills, renovations, it could be all sorts of other things. Now, so the answer, whilst the answer is no, the but bit is you're going to have to make some sort of an offer, if only to avoid the nuisance and the cost of legal proceedings. And that's perfectly reasonable when you think about it. If you have turned to someone for help and they've taken on responsibility and liability, they're going to expect, particularly as it's now a contentious phase, if you're listening to this vlog, they're going to want a little bit of a, you know, some money, aren't they? The key thing is, how much should that be? Okay, so that's the headline answer. I'm just going to explain to you now the legal landscape that will help you to understand that answer. Now, I have done lots of vlogs on cohabitation property disputes over the last few years. On my YouTube channel, there is a playlist that has all that category of legal vlog on it. So please do avail yourself of that playlist section on the channel. But just to give you a whistle-stop tour, Lady Hale comes to mind. She was actually the judge who presided over the prorogation issue that was raised by Boris Johnson before the Brexit general election, you might recall it. And so she's an extremely senior judge of the Supreme Court, and she's been involved in the landmark judgments, two of them actually, Stack and Dowden and Jones and Kernot are the most established ones in recent years. And she essentially says in her leading judgment, look, the fact of it is that, you know, if someone is on the title deeds, then the courts do have to give force to that, you know, very official documentation. That is what's called the legal position, right? In the case of land law, property law, what you have is often someone being a legal owner and someone being a beneficial owner. Classic cases in a trust, say, where you've got a trustee who is looking after an asset for children who are yet to come of age. He's the legal owner, in that example, for the pure fact that a child may not be able to, you know, own property at that age. So he's on the deeds, but the children are the real owners, if you like. They are the beneficiaries, so he holds on trust for them. So if you are someone who has gone on the legal deeds to help a romantic partner out, or help a sister or brother, etc. out, and you've become liable under the mortgage, you will be the legal owner. But Lady Hale went on to say, although that's the starting point, actually evidence can be produced to rebut that presumption, and that's not necessarily all that difficult. The presumption is that the common intention, if someone, you know, two people, let's say two people are on the deed, it could be just the one person, couldn't it? But let's take two people on the title deeds. The presumption is that the common intention, because that's what's on the documents, isn't it, with the land registry, is that the property is owned half-half. If there's no underlying documentation lodged with the land registry prepared by the conveyancing solicitors, you know, saying that actually it's being held in percentages of 70 and 30% or whatever it might be, or deposits should be returned and then the property is split in such and such proportions. If there is no documentation at the time of the purchase, and there often isn't when people are loved up when they're first buying a property together, then that is the presumption. But, as I say, she said it can be overturned by producing evidence to the contrary, that there was a different common intention. Now, if you've had, two people go on the title deeds, you're just helping out on the mortgage, and you've not paid any of the mortgage payments, it's over a period of 10 years, or maybe you paid a few at the beginning, you've either got a situation where it's clear that the person who's made those contributions owns in larger proportions, and the judgments in this area, do go quite a long way to saying that, the court can kind of open up the whole arrangement, look at the whole circumstances of the case. Let's say after 5 years, one party, as often happens, leaves the property, they separate. The courts are prepared to go into that and to depart from that legal position. Okay, so that's the presumption, and I should also say that my reading of the law in this area is that actually the Supreme Court decision is kind of saying to trial judges, because don't forget, very few cases get appealed, leaving the decision to trial judges to use their common sense. And using their common sense might be to say, well, you only paid X, therefore you're only allowed to 10%. And there was a common intention that the ownership should be unequal. Yeah. And indeed, the landmark cases I've talked about, at least one of them was quite significantly a percentage split, something like 10%, 90%, 20%, 80%. So the courts, the case authority clearly allows judges to depart from a 50-50 split. Okay, I should just say by way of a footnote here that there is a lot of debate about this. This issue keeps coming back to Parliament because the judges are annoyed, lawyers are just making hay out of this lack of clarity in the law, and a lot of senior judges want cohabitation law to fall into line with divorce, where it's kind of more straightforward. If it's a romantic cohabitation property dispute, make it like marriage and give cohabitants the same rights as they have couples who are divorcing. But that's unlikely to happen in my view. It keeps coming back to Parliament, but governments don't like the idea of giving cohabitation, but giving basically people who aren't married the same rights as married people. The institution of marriage, in short, should be held in high esteem, should be valued above people who are merely cohabiting together. Right, now I'm just going to look at a case study here. Remember, I'm going to try and, at the moment, just to focus on the person who is on the title deeds but hasn't made any contributions. Now, one of the most important cases, I guess, that this law firm has had, it's a few years old now, was a situation where the guy had made the vast majority of contributions to the mortgage over the life of the property. Yeah. They hadn't married and lived together. She'd returned to her home country, she'd come from overseas, and she instructed us. Now, in that case, and so often as not, these cases come down to fairly quantifying the contributions that have been made. They were both on the title deeds. In that case, she had, although she might not have made substantial contributions to the mortgage, if any, in fact, she had helped in a whole host of other ways. She'd assisted him in his ability to purchase the property. There were no children, incidentally. For example, he moved over to live with her overseas for a period of time, and she ran the property. She found tenants, she handled rentals, and so on and so forth. She made contributions in other ways to improvements in the property, and she had made some small share of contributions at the very early stages when they first bought it. Yeah. So in this, he didn't want to give her a penny. Bless him, he was very foolish about it, and it cost him because he had to pay our legal costs on top of giving her a substantial share of the equity. He wouldn't pay a penny, and so we brought proceedings to court on the basis that we were owed 50% of the property, because that's what the title deeds said. And it also clearly, that was the common intention when they bought that property together as a loving couple, planning to share their lives together. But it would have been unreasonable for us to fight that all the way to court. It was the classic thing that lawyers do: set your case at the highest, intimidate your opponent, and try and bring them to the negotiating table. Around about the same time we actually issued proceedings, we made offers, Part 36 offers without prejudice, offers for a much lower amount. I can't remember now what it was, which was 35 or 33%, and I think we made an offer for 25% at one point too. We made what we thought were generous offers, and we produced spreadsheets, Excel spreadsheets of the respective contributions, so that we had maths to support our position. And as I say, that settled very successfully for my client and successfully for us. We were on a no-win, no-fee arrangement, so we took 25% of the winnings. So if I can, just flip it round now and look at the perspective of someone who, is defending a claim brought by a party who wants 50% just because they're on the title deeds. And I've had a couple of cases quite recently that are exactly in this arena. You have got to bite the bullet a little bit. You've got to bite the bullet a little bit. You have to accept that the party, if they were on the mortgage, were liable if for any reason there was a default on the mortgage, and they had helped you out, and I'm sure that they might have made other contributions, perhaps not direct but indirect contributions to that property. The issue all comes down to fairly quantifying what a reasonable settlement is. And it is a piece of string question, depends entirely on the facts of your case. It could be £10,000 in a case that I'm currently instructed in. That seems about the right kind of figure. She made absolutely no contributions to the property whatsoever, and she's trying it on. She's using this cohabitation law of 50-50 if you're on the title deeds to try and get one on her opponent, our client. In that case, actually, it's not a romantic cohabitation issue. She's actually bringing proceedings against a sister-in-law. She went on the deeds with the sister-in-law. Now, you've got to be strong here. If your opponent is going to try and get a higher offer and issue proceedings and take you to court, you've got to pitch that offer just right, and it's got to feel fair as well. Do you know what I mean? Even though the law may be looking one way or the other, as I say, trial judges are actually often at the end of the day at trial, prepared to make their own fair, equitable decisions on this. But even so, you have got to do this fair calculation, and then you've got to put in a without prejudice offer, probably what's called a Part 36 offer. I explain that on another vlog on my YouTube channel. They're critical tools in this area of law, believe me. Now, the other thing to say as I now start to wind up this vlog is this is an area where mediation can be very helpful. I'm not always a great fan of mediation, and it can be used as a tactical tool. The courts are now telling everybody that you've got to try and settle before you come to court. You've got to exhaust means of alternative dispute resolution before you issue a claim. Where an opponent is playing the mediation game, trying to drag us to mediation and ring up a bill for mediation because it's not cheap, I'm minded to be more robust and say, well, we'll mediate, but only after we've issued proceedings. Okay, so you can mediate either side of the issue proceedings point. But as I say, I think it is a good idea, pre-issue, if not post-issue, to conduct a mediation, because your mediator will probably be a solicitor or a barrister, and you'll have to pay them a bit of money. You know, it's going to be $1,000 for a day's mediation, and the room bookings and so on. But I think it's probably worth it, because reason goes out the window, doesn't it, when relationships break down? And I think the mediator can help to instill an atmosphere of calmness and rationality into those sort of situations, and explain, I mean, they're not meant to give legal advice, but they can clearly indicate to both parties what the legal position is, and the serious danger of costs actually outweighing any ultimate benefit the parties are going to get. So do look seriously at mediation in this area of law. So to sum up, the answer is no, unless you've got a weak-willed person who's just, oh, I can't face the prospect of having proceedings issued against me. You can have half the property. If you're faced with that kind of opponent, then you probably might get 50% of the equity out of them if you're purely just on the title deeds. But if they're legally represented, certainly you are getting into dangerous and uncharted waters if you issue proceedings on a 50% basis. Certainly if you just do it without actually meaning to make a much lower tactical offer. But for the defendants out there, you will need to make an offer, and calculate what you think the contributions have been, direct and indirect, and then perhaps then add a little bit on top. Sweeten the pill, as it were. That's the very best approach to cohabitation property disputes. Okay, as I say, the law may change. Watch this space. Check the date of this video, but at the moment I don't see any prospect of it changing much in the future, because of the importance that governments and the Parliament place on the institution of marriage, which they want to hold sacrosanct and above, give rights to married couples over and above those of cohabiting partners. And finally, of course, I've mentioned no win, no fee. That is a perfectly appropriate tool if you do find a lawyer to represent you. Before you actually use them, just double check with them that they are prepared to do no win, no fee. Perhaps not initially, but if, let's say, you have to issue proceedings and the bill is going to skyrocket, check whether they'll do no win, no fee, or a discounted no win, no fee, where they might half their hourly rate in return for 15% of the winnings. This happened in actually a successful case with us just a few months ago. In fact, I don't think I've ever had, touch wood, any unsuccessful cohabitation property dispute cases. We've managed to usually get rather a lot more than the client would have got had they not used us, and we've done a lot of these, not all, on no win, no fee. So check that your lawyer is prepared to do no win, no fee. It's something I'm passionate about. If they think your case is strong, they should take a calculated risk and park their legal fees until successful resolution of the case. Okay, and finally, by way of plug, do go onto the playlists of the YouTube channel. You will find other vlogs on this topic there, and I am bringing out a book. I've already published part 1. It's called Flying Solo. It deals with small, fast and multi-track county court claims. So it will cover cohabitation property disputes, and I do give examples in that book. I'm bringing it out in 8 parts. They'll be published every few weeks or every month or so, and then once we've produced once we've finished, we'll produce a single book, but that might be a few months, if not 6 months or so, off. Okay, if you do want legal advice and help, you know where to get it. Please subscribe. Look forward to vlogging to you in the very near future. Bye for now.